I don't think it's just a blow. I think it's a death blow to an independent judiciary. You are basically replacing the Supreme Court of Pakistan with the Federal Constitutional Court. That Federal Constitutional Court, the first batch of judges and the Chief Justice of that court will be appointed directly by the Prime Minister. He may pick amongst serving Supreme Court judges, retired judges, High Court judges, or from directly from lawyers. When you allow the executive to, and we've seen already in the appointment of judges to the constitutional bench that there was absolutely no criteria for it, any constitutional expertise. In fact, within the Judicial Commission, all the judges save one, Justice Aminuddin, had said that there needs to be some criteria for appointment to constitutional benches. Whether it be seniority or it be familiarity with constitutional law, etc. The government said no, we'll appoint them as we like. This constitutional court will have even fewer constraints because there won't even be a dissenting voice. There'll be just the prime minister. So you can safely then the new constitutional court will not be bound by any of the past decisions of the Supreme Court. So the entire common law, jurisprudence that you have built up over the last 80 odd years, that's all out of the window. The new court can lay down its own jurisprudence as it likes. If that wasn't enough, the transfer powers that have now been vested if with the Judicial Commission, but as we know, the Judicial Commission is dominated by the executive. Those transfer powers allow you to transfer any judge from any high court to any other high court. If he or she refuses the transfer, they stand retired. Similarly, at the top end of the scale, when chief justices are being appointed, if a chief justice, there are they can pick one out of the top three, and if the nominee refuses, then all three stand retired. It just basically ensures that there are multiple means for the government through which that they can completely control the control judges, and therefore I think the concept of an independent judiciary is presently done and dusted in Pakistan. So the Supreme Court will serve as the highest appellate court for non-constitutional matters. And even, in fact, I shouldn't just say non-constitutional matters, because the jurisdiction of the constitutional court will be wider than just constitutional matters. We often, we understand in layperson's terms constitutional cases to mean cases that involve the interpretation of the Constitution or the testing of some legislative act against the Constitution. But the way it's defined in the 27th Amendment, it's not restricted to that. It basically says that all appeals from the high courts under stemming out of petitions under Article 199 shall also end up before the Federal Constitutional Court, barring rent cases and family cases. Rent cases and family cases will still go to the old erstwhile Supreme Court, whilst everything else goes to the federal court. Now, what is Article 199? Article 199 is your entire set of petitions for judicial review. Article 199 is your entire set of petitions which are directed against governmental actions. So every time any application for judicial review. So anytime any citizen, any business, any taxpayer is aggrieved by some action of the government, a government functionary, a government instrumentality, the remedy for him is to file an application for judicial review under Article 199. Now, all of that has been given firstly to the constitutional benches in the High Court, and then the appeal from that goes to the Federal Constitutional Court. So basically, anytime any citizen is aggrieved by an action of the government, when he goes to court, he can rest assured that at the final stage, before the Federal Constitutional Court, his case will be heard by judges, specifically appointed by the Prime Minister for that purpose. So the entire idea of separation of powers is lost. And naturally, with that, confidence in the judicial institution will be, irremediably lost. To begin with, I mean, it is a ridiculous argument, right? That you need to reform the Supreme Court in order to make justice more speedy in Pakistan. The Supreme Court has roughly 55,000 cases before it. Okay? The total pendency of cases in Pakistan in different courts, which are not the Supreme Court, is about 2.4 million. So the Supreme Court, the cases before the Supreme Court make about 3% of the total. And if you analyze it, and various studies have been done on that, the time, even the cases that end up before the Supreme Court. Now, if in the Supreme Court it takes 2 to 3 years to decide them, it has already spent 20 years in the courts below, in the high courts, in the district courts, etc. So the delay, both in terms of numbers and in terms of the actual delay itself, the Supreme Court is the least part of the problem. There are lots of other problems with the Supreme Court which should be tackled, but as far as delay in the judicial system is concerned, the Supreme Court is an insignificant, contributor. Now, but all the reforms that you see are always directed towards the Supreme Court. There has been, for example, no move from the government. Now, we had the 26th Amendment a year ago, and now we have the 27th Amendment, in less than a year. But our Civil Procedure Code dates back to 1908. Our Criminal Procedure Code dates back to 1898, right? In 80 years, the government has never, come around to framing a new procedural code or a new criminal procedural code, so that the actual cases which affect the ordinary litigant, the ordinary public, so those could be expedited. The reason is because their only interest is in cases of massive political importance, which are usually decided by the Supreme Court. And the interest of our political elite and our establishment is that the Supreme Court should somehow be tamed in a way that protects their political interests. The actual litigant public can suffer as they have been doing for decades. So it was necessary because in the Islamabad High Court, it so happened that there were, 5 or 6 judges over there who were not servile, right? And they continued to pass decisions that that the government perceived as being against their interests. So a chief justice was brought from another high court to take over that high court, and a couple of other judges were brought in, and it was basically a hostile takeover of the Islamabad High Court. But I mean, the reason why these judges couldn't simply be posted to Balochistan or Sindh, whatever, was because the article of the Constitution requires the consent of a judge before he be transferred. Because under our constitutional system, all the high courts are independent institutions, right? They don't belong. It's not the situation like you have in the civil service of Pakistan. A civil servant who enters the CSP is part of a unified federal service. He may be posted in Karachi, he may be posted in Peshawar, Islamabad, etc. But it's not like that for the high courts. So, in order to allow for this, they needed to amend the constitution, and they needed to take away the consent, because obviously if otherwise the government was helpless when consent was not given. Now, incidentally, this provision removing the requirement for consent. Now, the original constitution didn't allow judges to be transferred without their consent. Um, Zulfikar Ali Bhutto, when he, in his last period, when he was trying to establish control of the government over the judiciary, during the fifth and sixth constitutional amendments, he brought that in. Then Ziaul Haq jumped on it, and he elaborated on it. In the 18th Amendment, they actually removed that. They said that this is against judicial independence. We can't just pick up a judge from, Karachi and post him to Multan. This affects the independence. Just the way transfers, even within the bureaucracy, transfers and postings are used as a mechanism of both coercion and inducement. Bureaucrats who are pliable and favorable to the political masters, they are given prize postings. Those who are resistant are, posted in, in far-flung areas without any real powers, etc. So the obvious intent behind this amendment is to ensure that judges are in exactly the same position as civil servants. So I think this is probably, in some ways, this is even more significant. In at least in practical effect, it may be even more significant than, the abolition of the Supreme Court and the creation of the Federal Constitutional Court, because it effectively sets up a lifelong dictatorship in Pakistan. Now, the de facto position, as we all know, is that all the shots, and both domestic and international observers and governments also recognize that the effective power in Pakistan rests with the army chief. That de facto position is to a large extent now being institutionalized. And forget just institutionalizing that de facto position, it has been individualized, right? Because there's presently one field marshal. I mean, you may have a clause that says that yes, air marshals and admirals of the fleet, etc., will be given the same treatment. But effectively, there's one field marshal in Pakistan today. The constitutional amendment says that the field marshal shall hold office for life, shall hold his rank for life, sorry, I should say, and he cannot be removed by the government. The only way to remove him is by a two-thirds majority of parliament. So basically, that renders him practically, he's there for life. and it rids you speak of civilian supremacy, it rids the military from any kind of accountability to the government as well. I mean, accountability can only be there, if the authority to whom you are accountable has the power to remove you. If that authority does not have the power to remove you, then you are not accountable to him, right? And the most interesting part of it, I think, perhaps, is Article 243(4). Now that says that so there's a distinction, right? There's the rank of the field marshal, and there is the chief of army staff, right? So which is the office. Now they're obviously today they're joined in one person, but theoretically, they could be separate. You could have a field marshal who doesn't do anything, etc. But the interesting thing in Article 243(4) is that it says that even when the actual duties of the chief of army staff, when the term of the chief of army staff under the law, which is the Army Act, even when that expires, a field marshal can be asked to carry on duties as may be deemed necessary in the national interest, right? So currently the situation is the Army Act says 5+5, right? There's a 5-year term and then he can get a 5-year extension. But let's say that you take all 10 years together. In 2033, the term ends, and maybe there are people aspiring to become army chief then or whatever, but all that is needed is a notification from the government that the field marshal in the national interest should continue to carry on his functions until such time as he enjoys life. And because he has lifetime, the field marshal is there for life anyway. The rank is there. So, I mean, basically, you've transitioned, from, a hybrid democracy, perhaps, to a full-fledged dictatorship. Look, I think as far as civilian presidents, prime ministers, etc., are concerned, right? Um, when courts want to, there are various constitutional clauses that give some sort of immunity to them, right? And when courts want to pierce through those cloaks of immunity, they do, right? And there are various jurisprudential concepts, one of them being that any kind of immunity, even a constitutional immunity, will not protect acts that are malafide, or wholly without jurisdiction, etc. Those immunities are meant to cover official acts carried out in good faith, etc. So there are multiple devices that, as far as civilians are concerned, the courts have used in the past to pierce through those immunities. As far as the military is concerned, I think one present fear was the Musharraf trial. It was seen as an indignity by senior officers within the military, etc. And then even afterward, even after his death, proceedings continued. So that is something that the military has tried to ensure protection for the that I think when it was I don't know if it's not still there in the final draft, but when it was said that the field marshal will enjoy immunity from court process, so I think that was the intent behind it, that at least the military should be spared that indignity. And as we have seen in the past, even the interpretation of our courts, is often different. The constitutional interpretation they take is often different, when it comes to civilians and when it comes to the military. And I think that trend will only be enhanced now when the Federal Constitutional Court is in operation. So the main and primary objective, obviously, was Article 243. And that is evident from the fact that, all the parties, they started by saying, including the PPP, they started by saying, okay, look, we're agreed on Article 243, but can we discuss the other provisions, right? Which clearly, indicates what is the central, reason behind the amendment and what is not negotiable. The rest of it, I think, as far as the courts are concerned, they saw, because after the 26th Amendment, the court had already been emasculated to a great degree. And they saw the opportunity to be able to finish it off altogether. And so they've taken that opportunity. These are the only two basic things, right? There's the position of the field marshal and the creation of the federal court. All the rest are just machinery provisions. If they want to, there are numerous paths available to the judiciary. This kind of thing is obviously it's not unique to Pakistan. It's happened elsewhere. There have been constitutional amendments elsewhere which have sought to, change the judicial architecture, right? Actually, change the judicial structure. And courts, when confronted with such a position, so let's say you have a position where Parliament says, okay, now the Supreme Court doesn't comprise 15 judges, now it will comprise only 8 judges, and these are the 8 judges, right? This question has come up in different countries, and the answer has been that if to examine the validity of this legislation, we have to accept it and act according to it. So then that's just a contradiction in terms, right? So the assessment, the scrutiny of the validity of that legislation will be carried out by the existing judicial forum. If it considers that it passes muster, then obviously everything else will be done as per the legislation. But to insist that no, we will first implement it and then the amended forum will look at it. So that would just make any kind of constitutional protection or any kind of constitutional scrutiny meaningless. So that is the answer globally. And it is even, in fact, the answer in Pakistan. Even during military regimes, right? You had, as soon as a dictator would walk in, he would, pass the CMLA, the orders, right? The MLOs. And, the first thing in that would be that, no court shall exercise the power of judicial review, right? And all powers were vested with the various military functionaries. And even when those were challenged before the Supreme Court, the government would say, look, you don't have the power to scrutinize these because we've taken away the power. And even in the Nusrat Bhutto case, the Supreme Court, and in the Zafar Ali Shah case, when Zia's martial law was being challenged, and in the Zafar Ali Shah case, when Pervez Musharraf's martial law was being challenged, and they had these provisions there. And the Supreme Court said, look, the existing court has to decide, whether this removal of judicial review powers is constitutional or not. And in the end, I mean, those courts were compromised and they did say, well, look, whatever you've done is okay. But the power to scrutinize, obviously can't be denied. That is something which our constitutional bench has been denying for the last year in the 26th Amendment case. And frankly, I mean, that letter, a colleague, said, I want to write that letter. Will you sign it? I said, I'm happy to sign it. But frankly, I don't see much hope. I think probably, the Justice Chief Justice Yahya Afridi will be the last Chief Justice of Pakistan. And I think probably the epitaph for him would be, Yahya fiddled while the judiciary burnt, what was said about Nero.